Great. Yes, we have kind of a hodgepodge. I'm going to talk about changes in pregnancy accommodation requirements, change in the standard to religious accommodation, and a new statute that changes the Workers' Compensation Act and the scope of the bar or the exclusivity provisions. So the old standard, or what I think of as the existing standard, at least in Maine and under federal law, was that pregnancy is not a disability. Certain medical conditions might flow from pregnancy and might take you into ADA land, but generally speaking, pregnancy was not a disability, even if it created restrictions, in part because it's a temporary status. And so the obligation was really just to do for pregnant women what you did for other people who are not pregnant and had restrictions at work, and the same for leave. Two changes, one very recent under federal law, one less recent, 2019 under Maine law, but it was a bit of a sleeper amendment, or at least the meaning of it, I think, was kind of a sleeper. And I think we only recently really realized the extent that the change to Maine law changed the expectations. So now, starting with Maine law, this change to Maine law, again, from 2019, it provides an explicit right to accommodations for pregnancy-related conditions. And in a little bit, I'll talk about how broad we need to think about pregnancy-related conditions. It's really remarkably broad. And the statute requires reasonable accommodation unless it would impose an undue hardship. And those terms, reasonable accommodation, undue hardship, I know you're very familiar with them, but you're familiar with them in an ADA context. And actually what the Maine Human Rights Act requires, and likely federal law now, is not the same as the way you think about it in the ADA context. In particular, there's this term of art under the ADA and the Maine Human Rights Act when we're talking about disabled employees with disabilities, a qualified individual with a disability, who is somebody that can do the essential functions of the job with or without reasonable accommodation. And so there's this little circle that, therefore, a reasonable accommodation of an employee with a disability does not include eliminating essential functions. Otherwise, they're not qualified. That does not exist in the world of pregnancy accommodation. And the initial Maine bill actually included, it tied the pregnancy accommodation right back to the qualified individual analysis. And that language was stricken. And the rationale for it is that unlike disabilities, which are by definition, if not permanent, not transient at least, pregnancy-related conditions, or pregnancy itself, is a temporary status. And I think that's, from a policy perspective, why there's a higher standard. But in a minute, I'll explain why I'm not sure that rationale holds with all pregnancy-related conditions. The other change is more recent, and this is a federal statute that applies to employers with 15 or more employees. And it similarly requires reasonable accommodation for the known limitations related to pregnancy, childbirth, or related medical conditions. And it similarly doesn't tie back to a qualified individual with a disability analysis. Okay. This is, there's some EEOC guidance that out there that talks about sort of the breadth of what a pregnancy-related medical condition is. And it's broader than pregnancy. It's really anything relating to fertility in many ways. And so, I mean, some of these side effects, expressly accompany pregnancy or post-childbirth, right? Like carpal tunnel, anxiety, gestational diabetes. But others, such as abortion care, or it's not on the slide, but fertility treatment does not. And fertility treatment is, also temporary insofar as there's a point after which, age precludes conception, but that can be a much longer process than a pregnancy can be, sadly. And so I've had a number of clients, particularly like in the medical space, who will have an employee who is undergoing fertility treatment, and, for example, wants not to be exposed to radiation or not to be exposed to X-ray, all, appropriate and recommended by the doctor, also essential to their job if in fact they are, working with a radiologist. And so this is just one that, you have to think about pregnancy significantly more broadly here. And if you have to excuse an employee from performing the essential functions of their job, what kinds of accommodations are we looking at here? And here too, some of these are very obvious and probably not very controversial. In most jobs, at least, an opportunity to sit, lifting restrictions, but others like reassignment might be, or light duty work might be. I guess the takeaway here when it comes to pregnancy accommodation is that you really have to suspend all of the rules that you've kind of internalized around what is reasonable and what isn't reasonable, because we internalize those in the context of disability accommodation, and this is different. So, any questions or comments about that? Right. Let's talk about religious accommodation. So for a long time, the standard, another place where the standard of accommodating is not the same as it is under the ADA has been religious accommodation under Title VII or the Maine Human Rights Act or state laws. And for a very long time, like 50 years, the law has been that a reasonable accommodation is something that doesn't impose more than, if it imposes more than a de minimis burden, that's an undue burden. And that's an accommodation that you don't need to provide an employee. And there are lots of cases that talk about more than a de minimis burden being something that is hard for other employees, as accommodations often are. And in the context of religious accommodations, we're often talking about work schedule and Sundays off. That's probably the most common request for religious accommodation that you'll get. And so the law that's developed has essentially been, the employer needs to, allow the employee to swap shifts, but an accommodation that's going to make other employees work every Sunday so this employee can have Sunday off, probably not reasonable. And we've been waiting for this issue. For years, there's been an indication that this would be reconsidered if the appropriate case went to the US Supreme Court. And it did, and they did. And so in this decision from just last June, it involved a Postal Service employee, Sunday, couldn't work Sundays. The employer continued to schedule him. They allowed him to seek volunteers and to cover his shifts. That wasn't always successful. And when he missed work on Sundays because he couldn't cover his shifts, they disciplined him. And, so it went for some time until he had too many absences. And he eventually resigned because termination was in front of him. The writing was on the wall. Under the former standard, this would have been pretty straightforward. The court, in this case, really the plaintiff wanted something that looked a lot exactly like the ADA. So really the plaintiff's play here was to get the court to hold that undue burden under Title VII means significant difficulty or expense, which is really what it means under the ADA. And they didn't quite go there. They still used some language that's new. It's a fact-specific inquiry that focuses on whether a burden is substantial in the overall context of an employer's business. And the case, suggests you consider the practical impact of the accommodation in light of all the things that make, your operation, your company unique. And impact on coworkers, it's only relevant to the extent it impacts the overall conduct of the business. That's sort of, those are words, and I don't really know what those words mean. The court expressly rejected an invitation to tell us that we should look to ADA case law to inform what all of that means. So what does that mean? I'm really not sure. I wish I could be more helpful. I think we're going to watch it play out, over the next few years. It definitely means that you can no longer deny a request for accommodation simply because it will result in other employees working more Sundays than they otherwise would have. I think that's clear. One thing I've had a couple of calls where I've advised clients since this decision, including Sunday work. And one thing that is kind of similar to the ADA that I think works here is that you don't have to, you can get creative. So, if an employee, for example, if the practice is employee is expected to work every other weekend, and if they can't work Sundays, perhaps they work every Saturday, right? That's an accommodation. It doesn't impose, it takes the burden off another employee who would otherwise be working every Saturday. It meets the employee's needs. And so that, I think in that way, I think we are a little bit more in the ADA world where we're being interactive and creative and thinking of other possibilities. A couple of other things that I think are likely to come about now. I suspect that we may see employers trying to focus more on or challenge the sincerity of employees' religious beliefs, which has always been a loser argument because we always suggest that, unless the employee's articulation of their religious belief is just like patently ridiculous, and sometimes even when it is, that we credit that because the courts do not want to be engaged in determining what's sincere and what isn't, and religion isn't science. So, it's not like there's some book that we can open and compare this belief system to something scientific. But still, I wouldn't surprise me if we see more case law developing what that means. And second, I think if you haven't already, I do think employers are going to see significantly more requests for religious accommodations around Sundays, and or particularly around work schedules. And that's a real challenge. Perhaps that's when enough employees are requesting a particular day off, and that's a day that your business needs to service customers or patients or whatever they're servicing. Perhaps that's the point in time where we can say, in the context of our business, or, satisfy their vague burden that is substantial in the overall context. Well, if nobody can work on Sundays, then we can't run the business. So perhaps that's how it'll be tested, is the number of people who request it, but who knows? Questions or comments about religion? Yeah. If they say I can't, if they say I cannot work Sundays, you might have to consider that as a reason. It's not different than the disability context. Yeah, you might have to consider that. And I know that's a challenge when you're specifically hiring for a weekend position. Others? Okay, let's talk a little bit about workers' compensation. And I should have said Maine, because that's what I'm talking about here. I'm talking about a change in the Maine Workers' Compensation Act. Massachusetts and I believe New Hampshire already operate a little bit differently than Maine. So as you all know, I think, workers' comp, as much as you try to keep workers' comp claims down, the Workers' Comp Act is actually a tremendous benefit to you insofar as if we didn't have the Workers' Compensation Act and an employee injured themselves at work, they would be suing you in tort, right? And so this is really designed to be a benefit for employees, but also a benefit for employers. It's no fault, but the remedies are limited to the wages and medical costs. And so when an employee tries to bring it, and by tort, I mean negligence, defamation, claims that the employee was harmed because the employer did something wrong. When employees try to bring those tort claims, that claim is vulnerable to dismissal because of what we call the exclusivity of workers' comp, right? If you're injured in the course of work, that's your only remedy. And in Maine, that has been incredibly broad. I mean, there are cases that have gone to our highest court in Maine where an employee of a convenience store took out the trash at midnight and was murdered in the parking lot. And that's barred by, that's a workers' compensation claim, right? Not an assault claim, or there are sexual assault cases, that sort of thing. There are states, including Massachusetts, I know, where intentional acts are not subject to the bar. Okay, and that's sort of where Maine was headed, but not quite where we ended up. So initially, this proposed amendment spoke broadly of intentional acts. So it could have been a lot broader than it is. What we actually ended up with is the statute being amended so that the bar doesn't prevent a tort action against individual employees, supervisors, officers, or directors. So just individual people, not the corporation, in cases involving intentional sexual harassment or assault, which I think is always intentional. So in those cases, the comp bar will still preclude a lawsuit against the employer, but not against the individuals. Okay. Why does that matter? Let's just talk about it in the context of sexual harassment, because we have a statute, the Maine Human Rights Act, or Title VII, and under those statutes, the employee, if they are sexually harassed in the workplace or assaulted, that's probably sexual harassment too, can sue the employer for damages. And that's always, it's always been the case that they can do that and are not precluded. Those claims are not barred by the workers' comp bar. Now, those statutes also don't support, in Maine, don't support individual liability for supervisors or managers or directors. So an employee who's sexually harassed in the workplace will sue the employer under the Maine Human Rights Act or Title VII, and they will generally not, they'll be precluded from bringing a claim against an individual supervisor. That's no longer the case. So now an employee could have a claim in tort for assault in the workplace. There's a question in my mind about how much this actually matters. Well, it's sort of scary for individuals and probably should feature prominently in your anti-harassment training going forward to scare people into compliance. As a practical matter, there's something a really significant function of the anti-discrimination laws like Title VII and the Maine Human Rights Act that doesn't exist in tort law, and that's attorney fee shifting. So an employee who's sexually harassed in the workplace now can call one of many, fine plaintiffs' employment lawyers in Maine who will take their case for free and will take 33% of whatever they recover if the case is settled. Or if the case isn't settled and goes all the way to trial and the employee wins, the court will order the employer to pay those attorney's fees. And if the employee loses, then the employee and the lawyer are out of luck. But that's how the system functions. With tort claims, like negligence claims, there is not attorney fee shifting in that way. And so there may still be plaintiffs' lawyers who are comfortable taking those cases on a contingent fee. But at the end of the day, when it comes to like a settlement, there's not a way to force the employer to pay for the employee's fees. So yeah. I don't know the answer to that. I'd love to hear if anyone has heard. Like EPLI insurers, you mean, like, are the employment practices liability insurers gonna? That's a great question. Will there be carve-outs for claims against? Yeah, probably. I mean, that's important because usually those policies will say that they will treat as an insured a number of individuals in the workplace. I bet they'll carve out these. Yeah. Well, this is individuals can be. Yeah. So for the employer, the bar still applies.
Yeah, right.
Right. But yes, I wouldn't be surprised if the EPLI carriers say, we'll cover claims against the general manager unless it's a claim of intentional sexual harassment or sexual assault that's carved out. Well, I guess theoretically, workers' comp premiums could go down too, because the exposure there is right now, before this change, if an employee was assaulted in the workplace, that would be barred by workers' comp. There would be a comp claim there, assuming that they could satisfy, you know. No. Questions, other questions, observations? All right, I'll hand it over to Katie. To scare you further. This is scary topics.
I've got another reason why you should check on your EPLI coverage. Okay, so yes, the Maine Equal Pay Law, which predates the federal law. We know it well. It bars unequal pay on the basis of employees' sex, so opposite genders in doing comparable work on jobs that have comparable requirements relating to skill, effort, and responsibility need to be paid at the same rate. There are affirmative defenses that we know well, which I'm going to talk to you about right now. Under Maine law, you have an affirmative defense. You can have unequal pay between two folks of opposite sex, opposite genders, and now opposite race, if it's justified by established seniority systems, established merit increase systems, and you really want to have these things documented and actually established in practice, and differences in shift and time of day work. So if you have someone working the night shift at a hotel, maybe they get paid a little bit more than someone during the day, regardless of their gender and their race. So what's interesting about this is that we already know this. We have a lot of clients that have looked at their job descriptions for roles, essentially done an equal pay audit to make sure that folks in the same types of jobs are paid equally, regardless of their protected characteristic. And that's really how we should be approaching this, because yes, originally it was based on gender. Now it's been, now it's broader, has a broader reach to encompass race, but really you shouldn't be justifying differentials or to protect yourself. You should be really doing it on a neutral basis, regardless of protected characteristic. You want to make sure there's equal pay. And that's also important because under federal law, some employers may be covered by both Maine and federal, but most certainly by Maine if you have establishments in Maine. There isn't under Maine law a catch-all affirmative defense for factors other than sex. So under federal law, the Federal Equal Pay Act, you can justify a differential in pay on the basis of sex on factors other than sex. And it's been, teased out in the case law to really mean a lot of different things. So in the district court decision in Mundell v. Acadia Hospital Corp., the court was very specific. We don't have that affirmative defense under Maine law. And on that basis, under federal law, they read in sort of discriminatory intent into that factors other than sex catch-all. But the district court judge was very clear, we don't have that kind of defense under Maine law, and there is no additional requirement. If you do have unequal pay based on gender, now race, you can't then say, well, we don't have any of these affirmative defenses under Maine law, but we didn't mean to. We weren't intending to do it. It was sort of an error, our bad, but not our intent. That sort of defense isn't going to fly in Maine as of now. This is a district court decision in 2022. It's been appealed to the First Circuit. We're still waiting to see what they have to say. But if you do read the decision, the analysis is pretty thoughtful that, looking at the statute, the Maine Equal Pay Law, there isn't a catch-all, factors other than sex defense, which was actually specific when you look at the legislative history of the amendments to the law after the Federal Equal Pay Act was passed. And there is no discriminatory intent requirement. So what this really requires is for employers in Maine to go back, if you haven't recently, look at your job descriptions, because really the test hinges on, comparable work. So like an exempt, non-exempt analysis, you're not going to look at the duties, you're not going to look at the job title. You're going to look at the duties, the content. And where you have maybe different job titles, but similar duties, sort of create bands. We're happy to help you with this, to look at, these positions are comparable on the basis of skills, effort, and responsibility. And therefore there's this, unequal pay in these 2 or 3 different roles. Let's think about that. Let's approach that and address it. And that's important to do to avoid unequal pay claims under Maine law and federal law, but also because pay transparency laws are coming down the pike. In fact, one was proposed in the legislature this past session. It had some traction, but it didn't pass. And we've seen in other jurisdictions, like in New York, there are pay transparency laws, which are quite complicated, that have been passed. And it's enabled employees typically to go to their HR departments and ask for, within my role, what are people being paid? What's the salary band? And so I think it's incumbent on employers in Maine just to sort of like get your heads around exactly what jobs are comparable and what's the pay for different people because of pay transparency and because of the unequal pay law.
What if an employer can say, okay, titles, but in the industry,
Yeah. I see yeah. Well, you know what I think what it boils down to is like their duties. If they are, society may value them differently, which is oftentimes under the federal analysis. That's the factors other than sex. Oftentimes they'll point to, we have all these surveys, these studies, we relied on those to then create this salary band for this position. And I'm sorry, they're different, but we did use data and it's from like reputable institutions. But we don't have that in Maine. And so I think you need to look at their duties and see what they're doing. And if they truly are essentially doing the same thing, you can't really justify, unless you have a seniority system merit increase, or there's like a shift in day differential of when they work, they need to be paid equally. Otherwise, you at least have a risk of a claim. And like I said, the importance of the Mandela decision is that intent doesn't matter. So it's a wage claim. Yes. Yeah, I think merit-based increase, and I might rely on some of my colleagues in the back, like Suzanne specifically, if you don't mind. I mean, my understanding of a merit-based increase is that it's going to essentially be a plan. So Suzanne, would it be based on like number of years worked and contributions? Right. Yeah. Yeah. And to be honest, I've never asserted that defense before, because I think it's a little squishy. Like if you didn't adhere to it perfectly, then you're vulnerable in that defense. But yeah, so that's kind of like a factors other than sex. If you actually adhere to it and you're like, it's performance based, and that's, subjective, but. I've received a little bit of. Mhm. Pay that person more because they have. Agreed. Yes. Agreed. Yeah. So similar. Mhm. Yeah, of course. So, to us, I guess, it sounds like from what you're saying, Yes, if you're going to value years of experience, I would have that written and factor that. Do you agree, Suzanne? That would be sort of like your merit-based years of experience equal a percentage increase maybe of some sort, or what do you think? Mhm. Yeah, and I think it'd be levels of experience, and then you'd have to have some heightened job duties as well that, you know, I think so. And then, how do they apply that? Do they deal with a different client base or, there's got to be a way, I'm sure, of like distinguishing them from the person with 8 months. Cause I mean, it makes logical sense they would be paid more, but yeah, it doesn't really provide for that explicitly, does it? Yeah. Yeah. That's a great, and of course, the job descriptions that you would rely on to justify unequal pay need to, or, differentials need to be accurate. That's the critical thing too. Okay, so this is not a sexy topic, but it is important because to your point, Elaine, this is another thing your EPLI insurer may be bringing up with you. Um, the Maine Human Rights Act damages caps increased significantly, in some cases more than doubled. And of course, what band you fall into if someone brings a claim against you under the Maine Human Rights Act depends on how many employees you have. So when I'm talking about these damages caps, I'm talking about compensatory and punitive damages. Compensatory damages are sort of like the nebulous damage groups where it's infliction of intentional infliction of emotional distress, loss of enjoyment of life, inconvenience, that kind of sort of nebulous thing, hard to pin down in solid dollars. But employees can recover for that. And it's also punitive damages really targeted at punishing the employer for willful violations of the Maine Human Rights Act. So significant increases. Just want folks to be aware of that because the concerns with these increases are, and when you look at the legislative file, so the history of what was originally proposed, where we landed, all of the letters submitted in between in the testimony, people were voicing concerns about, okay, well, this just means that if, a plaintiff side employment attorney is coming to me and threatening a claim, they see the potential settlement value a lot higher now. EPLI insurance is going to jack up my rates. And if we actually go to litigation, it's going to cost me way more. And that's so uncertain. So kind of are where we are. This is done and we have to deal with this, but something to be aware of, something to think about in your strategy on how you handle employee disputes. As always, document, and try to get ahead of them, especially because of these increases. And I just wanted to flag also, there's a decision in 2022, Bell v. O'Reilly, also in the Maine District Court, which acknowledges and affirms that under law, you can stack. If you have a plaintiff that brings both a state law and a federal claim in Maine, you can stack the damages. So if you get punitive damages, you can stack them. So you can recover more than $300,000 if you have 115 employees. That employee can potentially. So notable, but doesn't really change your day-to-day, just something to have in the back of your mind. And before I move on, any questions about the last two topics? Any more questions? Okay. So the last topic for me is Maine paid family leave. I'm sure you're all very aware of this and we're waiting for additional guidance. So we just kind of know the high level points. But in 2025, we're going to start taking the payroll deductions. So it's going to be up to 1% split evenly between employees and employers. January 1st, 2026, people can start using this. It's happening, it's coming. Covered employees, that's going to be all employees, part-time, full-time, as long as they've earned at least 6 times the state average weekly wage. So that currently is going to be $6,216. Job protection only going to apply to employees that have been employed for you for over 120 days. So if you have a new employee, they are entitled to take Maine paid family leave, but they won't be protected for taking that leave explicitly under the statute in the program until after 120 days. Caveat, you can't retaliate against someone for taking Maine paid family leave. So essentially, they're protected. Family leave is 12 weeks of job protected with the asterisks around it. Paid family leave for serious health condition, which is defined in the statute, to care for a family member with a serious health condition, to bond with the child during the first 12 months after childbirth, adoption, or foster care. There's an interplay between short-term disability there potentially. And then these other reasons here, which include safe leave, organ donation, and so on and so forth. Family member is a broad term. It's going to include any individual with a significant personal bond, like a family relationship, regardless of whether or not you're actually biologically related to them or have a legal relationship. 12 months of job protected leave with a 7-day waiting period for medical condition. And you can have intermittent leave with employees. Under the statute, it's going to be in increments of not less than 8 hours, but it could be smaller increments if you agree to do that with an employee, which of course I'd recommend you document if you decide to do that. The benefit amount, sort of a tricky calculation in a way. They get 50% of their wages. It's going to be at a rate of 90%. And more than 50% of the state average weekly wage. So the 50% is relating to the average weekly wage, is going to be at a rate of 66% of their average weekly wage. So they're trying to keep it, not an insanely expensive benefit, because obviously there's a range of salaries in Maine. As I said before, it's funded equally by employees and employers. Employers with 15 or fewer employees don't have to pay into the program. The employer doesn't, but you do have to facilitate the employee's payment. And the notice of leave kind of mirrors the earned paid leave. Reasonable notice if it's related to an emergency, illness, or sudden necessity. Otherwise, you should give notice well in advance. I suspect it's about 30 days, but again, guidance will come down the pike from the DOL on or before January 1st of 2025, I believe. And effective dates we talked about before, January 1st, 2025. There's the employee contributions, and it will be available for use on January 1st, 2026. This is important for a lot of our clients. If you have a private plan that sort of hits all of the requirements of the statute, then you can apply to the Department of Labor to be exempt from this state benefit. You do need to apply, obtain certification, and if someone, for example, if you didn't honor or you didn't adhere to the policy, if you get a complaint and that goes to the Department of Labor, they can actually take away your certification. So then you have to enroll in the state plan. So just a little heads up to be careful about how this is administered once it's rolled out in 2026. There's going to be a poster and a notice that needs to be provided to employees, and we will get the additional guidance in January 1st of 2025. So a couple more things before I hand it over to Dan. This bill that was passed, which went into effect September 19, 2023, prohibits employers from requiring licensed veterinarians from being bound by non-compete. This is just sort of a continuation, very specific to an industry of, I think, a general aversion to non-competes that I'm seeing, that we're all seeing these days. There was actually a non-compete ban that was proposed in the legislature that wasn't passed, but you wonder, things get proposed enough times, sometimes they pass. So just something to flag for everyone. There is proposed new EEOC enforcement guidance. The comment period ended yesterday, so we'll see once that rolls out, but a lot of the guidance in it just reflects the law that as we know it today. It does specifically talk about sexual or gender-based discrimination includes misusing someone's pronouns. So we've seen that in case law, but that's specifically in the guidance. Note that the guidance isn't law, it's guidance, but reflects case law. And what's notable about this guidance is it's the first guidance on harassment that we've seen in 25 years. So once that gets published, worth a read. It's really helpful because it cites a bunch of cases. So that's essentially the high level there. And then you may have seen our alert on this, but there is proposed expansion of workers' overtime eligibility. The significance there is that it would increase the exempt salary threshold from where it is now at $35,568 to $55,068 per year. As we all know, it's not to classify someone as exempt. It's not just paying them a salary and meeting the threshold. It's also the duties test. But what this means is that if you have the duties test, but you don't have the ability to pay someone that higher exempt salary, they're going to be non-exempt if this actually goes into effect, which we will wait and see if that actually happens. And one last note that I want to make about that is that in satisfying the threshold, employers can use non-discretionary bonuses and incentive payments that are fixed, like commissions, to satisfy up to 10% of meeting that threshold. So a little tricky rule, but we'll keep our eye on it and let you guys know. So any other questions? Yeah.
So we offer.
Mm-hmm. Mm-hmm.
Which I understand.
So I think what you could do, because in New York, they do it this way, where you can have, because they have a paid family leave statute and it's been operating for at least 3 or 4 years now. You can have, so every employer must pay into the state benefit. They don't have this option to opt out, but you can pay into the benefit and then you can have your own private plan, even if it's pre-existing, and you just pay employees the difference between them. The intermittent leave question, I think the way that I would handle that, if you want to have people take that 6 weeks and just take it in one block, you could do that. It's your private plan. It'll overlap. I think we'll wait for guidance to see how. I hope they address this, but maybe they can take this longer 12 weeks and some of that time can be used intermittently, but you can have that 6 weeks of your plan that sits on top in my mind that brings them to full pay for at least 6 weeks during this period. That sits on top and that runs concurrently. Like you could have in your private plan that it needs to be taken in one block. That's the way I think that I would deal with it.
Okay.
Oh yeah, it's not straightforward. It's going to be very complicated, but yeah. Okay, you're welcome. Dan. Oh, sure. Yeah. Mm-hmm. Of 26. As far as I know, it's January 1st of 2026, but I'll just double check for you. Yeah, they had moved it. Yeah, I think it's January 1st, 2026, but I mean, it gives you more time if it's May, so that would be nice. Right, because there's a concern about being able to fund it properly. Okay, I'll check on that and I'll turn around and tell you. Yeah.
Got one more.
Oh, no, one more, I'm sorry.
On an annual basis?
For bonding 1 year, it could be. Doesn't happen, but in the 3rd year, I don't know. I hope so. That would be nice. That's actually what that broad definition means.
I know the language together, but specifically as it relates to bonding.
No, I think it has to, what has to, it's your child. No, I think it's child, but we'll see. The guidance is gonna be helpful hopefully when it comes up.
You want some time to take off with your trip with your BFF, you're going your golf trip or whatever. Yeah, we're bonding. All right. Hi, everyone. Dan Strader. I'm here to give you a little update on labor law and some things that have been happening at the National Labor Relations Board this past year. Spoiler alert, it's not good news. So you might remember, I talked to, some of you might have been here last November, and I talked about the general counsel of the National Labor Relations Board, Jennifer Abruzzo, who's been very aggressive and kind of very activist in terms of her policy priorities. And she has a role as counsel in deciding which cases go before the board. And that's how she's able to drive policy, even though she doesn't make the decisions. And she had issued, I talked about this last year, she had issued a bunch of memos to her regional offices, basically saying, bring me these kinds of cases. These are the kinds of things I'd like to overturn, essentially, or have the board overturn. So we talked about some of those sort of in a predictive way last year. Several of those have actually come to pass this year. So that's part of what we're going to be talking about. I think it makes, I sympathize for anyone trying to run a business, because I think it is very challenging. The National Labor Relations Board, I think more so than any other federal or state agency that I know, is an explicitly political entity that has political appointees, and I think, we all gripe, I think at times, about the Supreme Court and, oh, they did this decision and they overturned, but there are still guardrails that guide what the Supreme Court does, and they do follow precedent and they do follow history. The National Labor Relations Board doesn't even make a pretense of doing that often. I mean, there are wild swings left and right and back and forth from administration to administration. So it makes it really difficult to know what the rules are. I think if I'm an employer under this particular board, I'm going to assume the worst possible outcome in any kind of situation that falls within their jurisdiction, because even if the law has not been changed today, we can kind of predict the way they might rule if our case was to get in front of them. And so I think you just need to be really careful. And so anyway, some of those things have happened, some maybe haven't yet, but I just think, sort of treading cautiously is the way to go. So I'm not going to get into the weeds. I don't think too much on these cases, just in the interest of time, and also just, maybe kind of boring, but I want to talk more big picture of the sort of the types of changes that we've seen. So one category we've seen a lot of changes is in terms of rules governing employment contracts. Specifically, there was a ruling in February of this year in a case called McLaren-Macomb that took aim at non-disparagement and confidentiality provisions in severance agreements. And so just to back up a bit, and I don't want to get into the weeds on the National Labor Relations Act, but what it broadly protects is what's called concerted activity, which is essentially the right of employees to sort of band together or talk together, talk to each other, talk to the public, talk to federal agencies in an attempt to improve their working conditions. And that's sort of a general description. It's a lot more broad than even that, but that is essentially the main right that the act is trying to uphold. And what the board said is a non-disparagement provision and a confidentiality provision in the severance agreement. I will tell you the ones at issue in this case were fairly vanilla. They're not that outside the norm of what I would see in any kind of non-disparagement provision. Just don't talk, don't disparage the company. Don't say things that would damage our reputation in the community, things like that. They said that that's unlawful because it would it could be reasonably construed by an employee as saying you can't talk to other employees about this bad stuff in the workplace. You can't talk to the public about this bad stuff in the workplace, which is part of your right in order to try to improve. You can't improve work conditions if you're not allowed to talk about what's bad. And so these what they would view as overbroad provisions, trying to silence what employees can say, are going to violate the act. And I want to pause just to make clear here, everything I'm talking about, except the very final slide, this applies to you even if you don't have a union. And I think probably almost none of you, if any of you do. And that doesn't actually matter in this instance. What the board also said is that even offering that kind of provision to somebody, even if you don't enforce it, is a separate violation. And the other thing that I think is sort of interesting or surprising about this, a severance agreement by its very nature is not with an employee, it's with a former employee who's no longer with the company. And they said, no, those people actually have rights under the act as well. And because they could talk to former coworkers, they could talk to a board agent who's investigating a labor complaint, and they would be potentially stifled from all of that by these kinds of provisions. So very, very tricky. I have not advised employers to stop using those, quite frankly, partly because I think the risks in some cases, or the rewards, I should say, of having those provisions in some cases outweighs the risks. But I think you need to be very careful, and it's not something I would do lightly without thinking it through and probably talking to counsel about. In some cases, I have stripped those types of provisions or sharply limited them. In other cases, I've used them more broadly. It's going to be a little more situation dependent, but the board would take issue with that. And the only kind of provision they say is definitely okay would be non-disparagement that would prevent defamation, like malicious lies. Well, that's already illegal, so who cares? Or that would prevent or protect like trade secrets. Okay, again, also legally protected. So to me, that's sort of like a toothless thing that you're allowed, they would allow. So anything that you would normally put in to sort of say, hey, don't badmouth us when you leave, they have an issue with. Another thing that they've looked at this term or this year is non-compete agreements, which was just touched on, obviously. And I think because non-compete agreements are already disfavored in Maine, in Massachusetts, in many other states, maybe less impact here, because I think a lot of employers are already moving away from the use of non-competes and trying to get more towards like non-solicits or something more targeted. But the general counsel, this was actually not a board decision, so it's not binding, but the general counsel issued a memo saying, except in very limited circumstances, that almost all non-competes, she believes, violate the National Labor Relations Act. Because the reasoning is those kinds of agreements deter employees from basically threatening to leave, right? The working conditions are bad. I'm going to quit. I'm going to go to this competitor. And those kinds of agreements limit that kind of action. And by limiting that action, it's infringing on their rights, or their sort of the way that they could sort of vote with their feet, in other words, to leave. Both of these rules, just to I guess one piece of good news, they won't apply to management personnel, because management personnel are already exempt from coverage under the act. So, and that's good news, because I think a lot of the people you tend to offer severance agreements to, the people that tend to have non-competes, are going to be management personnel. So that's good, I guess. But there are certainly other categories of people, salespeople, technical professional employees who don't actually manage, but are sort of higher level folks who have a lot of access to confidential information, where they might still be subject to coverage, and going to have a hard time using these kinds of agreements with them. Another line of cases dealt with expanding the definition for what counts as concerted activity. So concerted is the part of the definition that refers to it being a group complaint. An individual gripe is not protected necessarily by the act. Even before these cases, I would say the definition of concerted is fairly broad. It's not always easy to tell, because it also includes, so let's say you're in a meeting with a employee, and he or she is griping about a bunch of stuff, and they're yelling and screaming, and so all of a sudden they're acting really inappropriately or something. And you get upset about it, that you don't know, you might think, well, this is just this one person, right? But if they are speaking on behalf of others, or they're raising a concern with an eye towards it's going to become a group issue, or they plan to raise it with others, it just becomes very difficult to know in the moment what is or is not concerted. Both of these decisions expanded that definition considerably. The first one sort of applied a totality of the circumstances test to determine whether or not activity would be considered concerted. In other words, is it on behalf of or for the benefit of other employees and not just that employee themselves? But even one employee in a private meeting might be concerted. So I think the takeaway here is the definition of what concerted activity is so broad that I think you should, and it's almost an impossible decision to make in the moment. You really won't have the facts available to you in the moment to know, is this concerted? Is it not concerted? Is this person just complaining and being inappropriate in the way that they're doing so? I would just assume that anytime someone complains to you about literally anything related to the workplace, that it may well be protected. And so we should treat them as if they had blown a whistle, or whatever sort of analogy you want to draw. And all, like the cases that you see that even where behavior or activities found not to be concerted, it's something that they always figure out as like an after the fact rationalization. You can never really make that judgment well in the moment. So just be careful out there, I guess is what I'd say. This one is troubling. And this was on the general counsel's radar. I think I actually mentioned it last time, which is the rules for what it takes for an employer to justify an otherwise neutral workplace policy. It has been heightened. So you can have a work rule, and the common ones that come up here are like civility rules, confidentiality rules, professionalism, code of conduct, anything that talks about the way in which people behave or speak in the workplace. Those kinds of rules, and then they never say like you can't complain about wages, right? I mean, that's not what those rules say. They're not targeted towards protected activity, but those kinds of generally applicable sort of workplace conduct, speech type work rules are going to be unlawful under this new standard if they have the reasonable tendency to chill protected activity, unless the employer, so then the burden is on us to prove that the rule is narrowly tailored to advance a substantial and legitimate business interest. I think this quote is very telling in the next bullet, which is that these rules are going to be evaluated from the standpoint of the reasonable employee who is economically dependent on her employer and thus inclined to interpret an ambiguous rule to prohibit protected activity. So I don't know if that's not a loaded phrase. I don't know what is, right? But it's clear that the thumb is very heavily on the scale in favor of most of these kinds of rules. If any employee says, well, I thought that meant I couldn't talk about my wages because that might be deemed as rude or unprofessional or something, and they would say, the NLRB would say, well, that's an overbroad rule. It's unlawful. So I think it's really difficult. I think even before this rule or before this change in the law, you would be shocked at the kinds of employee comments and conduct that have been found to be protected by the board in various cases. And it's a little bit all over the place. There's sort of some cases, in terms of things like swearing at the manager, right? But if I'm swearing at the manager because I'm complaining about, my work shift or something, might be protected. Probably a pretty good chance I'm protected. I mean, there's a level at which you cross the line into abuse, but you have to go pretty far. And so these kinds of generally applicable work rules, you just need to be really careful. And I think you can do things in your policies but you could try carve outs, but even carve outs are hard. You can't just say something like this doesn't apply to protected activity under Section 7, right? Because employees aren't deemed to know what that means. You'd have to say something more like, this does not purport to limit employees from discussing their wages, work conditions, et cetera. I mean, you'd need to be a little more specific if you're trying to do a carve out. And then also I would try to get away from things like, rules about sort of being polite or appropriate or sort of these vague and sort of squishy terms. I think leaning more into harassing language, abusive language, extreme profanity, things like, that sort of thing. Because the board has long held that people can be passionate and often rude and disagreeable when they're talking about trying to improve their work conditions. You don't have to do that politely. So it is challenging. All right, and this is the last one, which may not hopefully affect a lot of you if you aren't in the middle of a union campaign, which hopefully you won't be, but I find it frankly terrifying, because this is a big deal. This was the board overturned a 52-year-old precedent that had said essentially an employer always is entitled to a union election to decide whether a union's going to come in. I think we probably take that for granted. It seems obvious, or you have to win an election to come in and sort of change the workplace. What this decision, but before that, and I think if you've heard of like card check legislation, I know I haven't heard about that in the last couple of years, but it was big maybe 5, 6, 7 years ago. I think the Democrats were trying to do it. It didn't happen. But that kind of legislation would say, when a union comes in, they get what's called authorization cards signed by employees that say, I'd like this union to represent me. That's not the same as their vote in an election, but it's sort of a preliminary petition signing, almost, that kind of thing, right? It's a way to get on the ballot, might be a way to think of it. And they have to get 30% of the people to sign those cards. And what card check legislation would be is, hey, if you get 50% of the people to sign the cards, you just win. And then we don't have an election. And that's kind of what this does. There's a little bit of an out, but it's a challenge. So what this says is if the union comes and presents evidence that they have a majority, which they would generally do by having 50% of the people sign these cards, and they show that to the employer must either immediately recognize the union and bargain with them, or they must, the employer, not the union, must go to the NLRB promptly. And I'm thinking, I don't think they've issued a rule on this, but it's going to be like 5 days. Yeah. Oh, it's going to be like days, like a handful of days. It's not going to be 2 weeks. I can promise you. And so then you need to run to the board and file for an election. And that could be problematic if, like, let's say the if you people maybe in your workplace, all the managers aren't sort of up to speed on this. Union guy shows sort of random supervisor A, hey, I got these cards. Maybe you as HR don't even find out about it for a couple of days. By the time you find out about it, there may already be like a union in place, right? So I think it's really challenging. And the other thing that's difficult about this is there was always this rule that if an employer committed an unfair labor practice during the course of a campaign, and that sounds really like, oh, I wouldn't do that, that's devious. They're really easy to commit. So there's all these rules about what you can say, what you can't say. It could be a stray comment from a supervisor, like in an employee meeting, hey guys, don't vote for the union. We're going to do right by you. We're going to fix things around here. That might be a promise that's unlawful. That's an unfair labor practice. No one would think that's horrible, but it might be an unfair labor practice. So those kinds of things usually would only affect the election if they were, first of all, serious. And even if they were serious, generally, the remedy would be redo the election. Just if you get a do-over, we start over. What this decision has now said is any unfair labor practice will mean the union wins, period. And before that, it was like egregious, repeated unfair labor practices could lead to that, but not like your run-of-the-mill stuff. So I just think this makes it really challenging. And without getting the weeds on elections, I think the takeaway for employers, if you're not unionized now, I would suggest doing training with your managers. I would suggest having conversations at the very least. And everyone needs to understand that if they hear the slightest whiff of anything, even if it's something that rhymes with union, they should be telling HR so that you can get in touch with counsel and act like immediately, because there's just no time to really deal with it. And there's so many ways in which it could go wrong before you even sort of know what's happened. So on that cheery note, if there's no questions, I'll hand it over to Pete. Any questions?